Welcome back everyone. Last few classes we have discussed various negotiable instruments, particularly cheque in detail. Suppose you are a payee of a cheque, you have received a cheque and deposited it to the bank. If bank accepts it and pay the amount to you, cash or in your account, so there is no problem. That problem is over. Bank may refuse your cheque also. If bank refuses the cheque, what will happen? Bank may refuse your cheque due to various reasons. Say, maker himself make the payment stop, then bank will refuse your cheque. Or the signature may differ with the specimen signature, then maker himself may expire after the issue of cheque, then also bank will refuse your cheque. Again, the figure, the amount written in figure and words may differ, then also bank may refuse your cheque. But if bank refuses the cheque due to the insufficiency of the fund, it is a criminal offense in the part of the drawer or maker of the cheque. So it is a serious matter. So today's topic is dishonour of cheque due to the insufficiency of fund. Due to the insufficiency of fund. Under section 138 of this Act, of the Negotiable Instrument Act 1881. I have planned this class this way. I will cover this topic under these points: amendment and punishment. What amendment have Government of India has done, or what are the punishment? Then before that amendment, what was the previous provision? Then what is the main objective of this amendment? And lastly, what are the procedure, how we can get rid of this problem? So let us come one by one. Amendment and punishment. In the year 1988, Government of India or Parliament amended this Act, Negotiable Instrument Act 1881. And under this section, amended section 138, with effect from 1st April 1989. Punishment is that double of the amount. If bank refuses your cheque due to the insufficiency of the fund, then the maker of the cheque has to pay double of the amount, or oblique and 2 years of imprisonment. Or oblique and means court will take decision depending upon the circumstances. You may have to pay to the extent of double of the amount, or 2 years of imprisonment, or both, to the extent of 2 years of imprisonment, or to the extent of both, you have to face the legal consequences. And this amendment has been done in the year 1988 with effect from 1/4/1989. Then what was the previous provision? How this problem was dealt with before this date? Before this amendment, previous provision was like this. Let me, it is okay, no problem. Previous provision was like this. Under section 415 and 420 of Indian Penal Code 1860, Mr. Droyer, or the maker of the cheque, was prosecuted under this section. If it is proved that intentionally he has issued a cheque without sufficient balance, it was to be proved by the payee. It was to be proved by a payee that he has issued the cheque knowing the fact that he has no sufficient balance at the bank account against which he has issued the cheque. But at present, by this amendment in the year 1988, this act has been tightened. This act means negotiable instrument has been tightened. In this act itself, provision is that the whole of the amount or 2 years of imprisonment. At present, payee need not prove about the intention of the drawer or the maker of the cheque. Simply, if it is evident that the drawer or maker of the cheque has issued the cheque without sufficient balance, he is liable for criminal punishment. Now come to the objective. Of this amendment. Why the government of India or the Parliament amended this act? The main objective is trustworthy substitute of cash. This is the intention of the government of India, to make the cheque trustworthy substitute of cash, so that cheque can be popularized. Instead of cash, cheque should be used by most of the people. This is the target of government of India. Now come to the procedure. How we can get rid of this problem, and what are the ingredients, we may say, we have to follow, or what are the conditions we have to fulfill. Procedure. To get rid of this problem, you as a payee have to fulfill some conditions, and these conditions are: number one, you have to deposit the cheque which you have received within 3 months. Within 3 months. Within 3 months from the date of the cheque. Within 3 months from the date of the cheque, you have to deposit the cheque demanding your amount before the bank. Number two, if bank refuses your cheque, bank will issue a banker slip mentioning that your cheque has been refused due to the insufficiency of the fund. That means you have to collect the banker slip. Banker slip, where it is mentioned that your cheque has been dishonored or refused by the bank due to insufficiency of the fund. Receiving the banker slip, point number 3, within 30 days from the receipt of the communication from the bank that your cheque has been refused, you have to issue a notice to the drawer. Notice to the drawer. Notice to the drawer or maker of the cheque within what? Within 30 days. 30 days from the date of receipt of banker slip. After that, number 4, receiving your notice, the maker or the drawer of the cheque will get 15 days time to repay your money. He may repay your money within 15 days. Within 15 days. He may repay your money within 15 days from the date of receipt of your notice. If he repay the money, he pay the money, suppose he pays the money to you, the problem is over. But he may fail. He may fail to pay the amount. In that case, fifth point comes, you have to submit a complaint within 30 days. Within 30 days from what? Within 30 days from the expiry of these 15 days. From the 30 days of expiry of these 15 days, you have to submit a complaint before the first class judicial magistrate for remedy. So, be careful. Whenever somebody is going to issue a cheque, verify the bank account first. Verify your deposited amount, whether it is sufficient for your cheque or not. Then only you issue your cheque to anybody. Thank you.